Article 19. Entering into more than one employment contract. 1. A worker may enter into employment contracts with more than one employer, provided they can ensure the full implementation of the contents in the concluded contracts. 2. Where a worker enters into employment contracts with more than one employer, the worker's participation in social insurance, health insurance, and unemployment insurance schemes shall be in accordance with the regulations on social insurance, health insurance, unemployment insurance, and occupational safety and health. Article 20. Types of employment contract. 1. Employment contracts must be concluded according to one of the following types. A. An indefinite term employment contract, which is a contract in which the two parties do not specify the term of the contract or the time at which it terminates. B. A definite term employment contract, which is a contract in which the two parties specify the term of the contract and the time at which it terminates, which will be no later than 36 months from when the contract comes into force. 2. Where an employment contract as stipulated in point B, clause 1 of this article expires and the worker continues to work, the following conditions apply. A. Within 30 days from the date of expiration of the employment contract, the two parties must conclude a new employment contract. Prior to the signing of the new employment contract, the rights, obligations, and interests of both parties as prescribed in the expired contract shall be maintained. B. If no new employment contract is entered into within 30 days from the date of expiration of the contract concluded according to point B, clause 1 of this article shall become an indefinite term employment contract. C. Where the two parties conclude a new employment contract with a definite term, only 1 additional definite term employment contract may be signed. After that, if the worker continues to work, an indefinite term employment contract must be signed, except in the case of individuals employed as directors of state-owned enterprises and other cases stipulated in Clause 1 of Article 149, Clause 2 of Article 151, and Clause 4 of Article 177 of this Code. Article 21. Contents of employment contracts. 1. An employment contract must include the following primary contents. A. The name and address of the employer, and the name and position of the person entering into the employment contract from the employer's side. B. The full name, date of birth, sex, residential address, identity card number or passport of the person entering into the contract from the worker's side. C. The work to be undertaken and the place of work. D. The duration of the employment contract. D. The work-based or position-based wage, form of wage payment, date of payment, allowances, and other terms. E. Policies for wage step upgrade and wage increase. G. The working time and rest periods. H. Personal protective equipment for the worker. I. Social insurance, health insurance, and unemployment insurance. K. Training, developing and enhancing occupational knowledge and skills. 2. When a worker performs work that is directly related to a business or technological secret as stipulated by law, the employer has the right to sign a written agreement with the worker on the contents and duration of protecting the business or technological secret, including benefits and compensation in the case of violations. 3. Where a worker works in the agriculture, forestry, fishery, or salt production sectors, depending on the type of work, The two parties may exclude some contents of the employment contract and agree on supplementary contents on settling cases where the execution of the contract is affected by natural disaster, fire, or weather. 4. The government shall stipulate the contents of employment contracts with workers hired as director of a state-owned enterprise. 5. The Minister of Labor Invalids and Social Affairs shall stipulate the details of clauses 1, 2, and 3 of this article.